Good morning, friends. My today's topic is on Section 482 CRPC, which is defined under 37th chapter titled Miscellaneous, and it talks about inherent powers of the code. Before going further, I will read out Section 482 of CRPC, which is as follows. It starts with the heading Savings of Inherent Power of High Court. Nothing in this code shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this code, or to prevent abuse of the process of any code, or otherwise to secure the ends of justice. Firstly, it does not start with non-ostensible clause, but it starts with nothing in this code. So it is a helping to the provisions of this CRPC provisions, and it is not going against those. Rather, it is serving the purpose that if any there is gray area under the inherent powers, it can do help. Otherwise, if they are clear-cut powers, it will not overrule them. But if the gray area is covered in the larger of interest of justice and to prevent abuse of the process of the code, or to give effect to any order under this code, then it will come into play. Now, I will discuss with you the criminal appeal number 1723 of 2017, which arrived out of SLPCR number 9549 of 2016. This is already on your screen. You can read it out if you are not covering through my listening or speaking. So, if we go by the para 10 of this judgment, it says that Section 482 is prefaced with an overriding provision. The statute saves the inherent power of the High Court as a superior court to make such orders as are necessary, firstly, to prevent an abuse of the process of any court, or otherwise to secure the ends of justice. So, these, to do these things, this provision is there. If we go by further case, that is Gyan Singh's case, which a bench of three learned judges had decided, and in this case, this court adverted to the body of precedent on the subject and laid down guiding principles which the Honorable High Court should consider in determining as to whether to quash an FIR or complaint in the exercise of the inherent jurisdiction. The consideration which must weigh with the Honorable High Court are that the power of the High Court in quashing a criminal proceeding or a FIR or a complaint in exercise of its inherent jurisdiction is distinct and different from the power given to a criminal court for compounding the offences under section 322 of the code. Inherent power is of wide plenitude with no statutory limitation, but it has to be exercised in accord with the guidelines and grafted in such power, that is, to secure the ends of justice or to prevent abuse of the process of any court. In what cases power to quash the criminal proceeding or complaint or FIR may be exercised where the offenders and victim have settled their dispute would depend upon the facts of and circumstances of each case, and no category can be prescribed. High Court must have due regard to the nature and gravity of the crime. Heinous and serious offences of mental depravity or offences like murder, rape, ducati cannot be quashed even though the victim or victim's family and offender have settled the dispute. Such offences are not private in nature and have a serious impact on society. Any compromise between the victim and the offender in relation to the offences under special statutes like the Prevention of Corruption Act or the offences committed by public servants while working in that capacity cannot provide for any basis for quashing criminal proceedings involving such offences. High Court may quash the criminal proceedings if in its views, because of the compromise between the offender and the victim, the possibility of conviction is remote and bleak, and continuation of the criminal case would put the accused to great oppression and prejudice, and extreme injustice would be caused to him by not quashing the criminal case despite full and complete settlement and compromise with the victim. High Court must consider whether it would be unfair or contrary to the interest of justice to continue with the criminal proceeding, or continuation of the criminal proceeding would tantamount to abuse of process of law despite settlement and compromise between the victim and the wrongdoer, and whether to secure the ends of justice, it is appropriate that the criminal case is put to an end. And if the answer to the above questions is in the affirmative, the High Court shall be well within its jurisdiction to quash the criminal proceeding. Now coming to another case, that is Narendra Singh's case. In Narendra Singh case, Honorable Dr. Justice A.K. Sikri, speaking for the bench of two learned judges of this court, observed that in respect of offences against society, it is the duty of the state to punish the offender. In consequence, deterrence provides a rationale for punishing the offender. Hence, even when there is a settlement, the view of the offender and victim will not prevail, since it is in the interest of society that the offender should be punished to deter others from committing a similar crime. There may be offences falling in the category where the correctional objective of criminal law would have to be given more weightage than the theory of deterrence. In such a case, the court may be of the opinion that a settlement between the parties would lead to better relations between them and would resolve a festering private dispute. The court observed that the timing of settlement is of significance in determining whether the jurisdiction under Section 482 should be exercised. Those cases where the settlement is arrived at immediately after the alleged commission of offence and the matter is still under investigation, the High Court may be liberal in accepting the settlement to quash the criminal proceeding investigation. It is because of the reason that at this stage the investigation is still on and even the charge sheet has not been filed. Likewise, those cases where the charge is framed but the evidence is yet to start or the evidence is still at infancy stage, the High Court can show benevolence in exercising its power favorably. But after prima facie assessment of the circumstances materials mentioned above. On the other hand, where the prosecution evidence is almost complete or after the conclusion of the evidence, the matter is at the stage of argument. Normally, the High Court should refrain from exercising its power under Section 482 of the Code, as in such cases, the trial court would be in a position to decide the case finally on merits. In another case, while dealing with an offence under Section 307 of the Indian Penal Code, following circumstances had weighed with it in quashing the first information report. It says that we have gone through the FIR as well, which was recorded on the basis of settlement of the complainant, statement of the complainant of the victim. It gives an indication that the complainant was attacked allegedly by the accused person because of some previous dispute between the parties, though nature of dispute is not stated in detail. However, a very pertinent statement appears on record, namely, respectable persons have been trying for a compromise up till now, which could not be finalized. This became an important aspect. It appears that there have been some disputes which led to the aforesaid purported attack by the accused on the complainant. In this context, when we find that the elders of the village, including Sarpanch, intervened in the matter and parties have not only buried their hatchet but have decided to live peacefully in future, this becomes an important consideration. The evidence is yet to be led in the court. It has not been started. In view of the compromise between the parties, there is a minimal chance of witnesses coming forward in support of the prosecution case. Even though nature of injuries can still be established by producing the doctor as witness who conducted medical examination, it may become difficult to prove as to who caused these injuries. The chances of conviction therefore appears to be remote. It would therefore be unnecessary to drag these proceedings further and waste the time of court. So, the broad principle which comes out from the above discussion are Section 482 preserves the inherent power of the High Court to prevent an abuse of the process of any court or to secure the ends of justice. The provision does not confer any new power, it only recognizes and preserves power which inhere in the High Court itself. The invocation of the jurisdiction of the Honorable High Court to quash a first information report or a criminal proceeding on the ground that a settlement has been arrived at between the offender and the victim is not the same as the invocation of jurisdiction for the purpose of compounding an offence. While compounding an offence, the power of the court is governed by the provisions of Section 320 of the Code of Criminal Procedure 1973. The power to quash under Section 482 is attracted even if the offence is non-compoundable. In forming an opinion whether a criminal proceeding or a complaint should be quashed in exercise of its jurisdiction under Section 482, the Honorable High Court must evaluate whether the ends of justice would justify the exercise of inherent power. While the inherent power of the High Court has a wide ambit and plenitude, it has to be exercised to secure the ends of justice or to prevent an abuse of the process of any court. The decision as to whether a complaint or a first information report should be quashed on the ground that the offender and victim have settled the dispute revolves ultimately on the facts and circumstances of each case, and no exhaustive elaboration of principles can be formulated. In the exercise of power under Section 482, and while dealing with a plea that the dispute has been settled, the High Court must have due regard to the nature and gravity of the offence. Heinous and serious offences involving mental depravity or offences such as murder, rape, and dacoity cannot appropriately be quashed through the victim, though the victim or the family of victim have settled the dispute. Such offences are, truly speaking, not private in nature, but have a serious impact upon society. The decision to continue with the trial in such cases is founded on the overriding element of public interest in punishing persons for serious offences. As distinguished from serious offences, there may be criminal cases which have an overwhelming or predominant element of civil dispute. They stand on a distinct footing insofar as the exercise of inherent power to quash is concerned. Criminal cases involving offences which arise from commercial, financial, mercantile, partnership, or similar transactions with an essentially civil flavor may, in appropriate situations, fall for quashing where parties have settled the dispute. In such a case, the High Court may quash the criminal proceeding if, in view of the compromise between the disputants, the possibility of conviction is remote and the continuation of criminal proceeding would cause oppression and prejudice. There is yet an exception to the principle set out in Proposition 8th and 9th above. Economic offences involving the financial and economic well-being of the state have implications which lie beyond the domain of mere dispute between private disputants. The High Court would be justified in declining to quash where the offender is involved in an activity akin to a financial or economic fraud or misdemeanor. The consequences of the act complained of upon the financial or the economic system will weigh in the balance. So the question arises, why the need for Section 482 CRPC? The power of the High Court under Section 482 CRPC are partly administrative and partly judicial. The section was added by the Code of Criminal Procedure Amendment Act of 1923 as the High Courts were unable to render complete justice. Even in a given case, the illegality was palpable and apparent. The Honorable Supreme Court in State of Karnataka versus Muniswamy, AIR 1977 SC 1489, held that Section envisages three circumstances in which the inherent jurisdiction may be exercised, namely, to give effect to an order under CRPC, secondly, to prevent abuse of the process of the court, and to secure the ends of the justice. What are the real powers of the High Court under Section 482 CRPC? Inherent powers under Section 482 of CRPC include powers to quash FIR, investigation, or criminal proceedings pending before the High Court or any court subordinate to it, and are of wide magnitude and ramification. Such powers can be exercised to secure ends of justice, prevent abuse of the process of any court, and to make such orders as may be necessary to give effect to any order under this code, depending upon the facts of a given case. Courts can always take note of any miscarriage of justice and prevent the same by exercising its power under Section 482 of CRPC. These powers are neither limited nor curtailed by any other provisions of the Code. However, such inherent powers are to be exercised sparingly and with caution. It is well settled that the inherent powers under Section 482 can be exercised only when no other remedy is available to the litigant and not where a specific remedy is provided by the statute. If an effective alternate remedy is available, the High Court will not exercise its powers under this section, especially when the applicant may not have availed of that remedy. So, coming to overall limitation of section 482 of CRPC, even though the inherent jurisdiction of High Court under section 482 is very wide, it has to be exercised sparingly, carefully, and with caution, and only when such exercise is justified by the test specifically laid down in the section itself. It is to be exercised ex debito justitiae to do real and substantial justice for the administration of which alone courts exist. This view has been taken by the Honorable Supreme Court in many of its judgments, including the recent judgment that is Monica Kumar versus of State of Uttar Pradesh. In a proceeding under Section 482, the High Court will not enter into any finding of facts, particularly when the matter has been concluded by concurrent finding of the facts of two courts below. In State of Bihar and another versus K.J.D. Singh, the Honorable Supreme Court had a question whether the criminal proceedings can be quashed even before the commencement of the trial. The Supreme Court went ahead and held that inherent power under Section 482 has to be exercised for the ends of justice and should not be arbitrarily exercised to cut short the normal process of criminal trial. After a review of Catena of authorities, Justice Pandian in Janata Dal versus S.H. Chaudhary has deprecated the practice of staying criminal trials and police investigation except in exceptional cases. In R.P. Kapoor versus State of Punjab, Honorable Supreme Court went on to limit the power of the Honorable High Court within the ambit of CRPC. It was held inherent power of the High Court cannot be invoked in regard to matters which are directly covered by specific provisions in the CRPC. So it is well settled that the inherent power under Section 482 can be exercised only when no other remedy is available to the litigant and not where a specific remedy is provided by the statute. If an effective alternative remedy is available, the High Court will not exercise its powers under this section, especially when the applicant may not have availed of that remedy. The Honorable Allahabad High Court went on to state that the section is sort of reminder to the High Courts that they are not merely courts in law, but also courts of justice and possess inherent powers to remove injustice. The inherent power of the High Court is an inalienable attribute of the position it holds with respect to the courts subordinate to it. They are necessarily judicial when they are exercisable with respect to a judicial order and for securing the ends of justice. The jurisdiction under Section 482 is discretionary. Therefore, the High Court may refuse to exercise the discretion if a party has not approached it with clean hands. So, conclusion is Section 482 CRPC has a very wide scope and is an essential part of statute to meet the ends of justice where injustice can take place, but at the same time the said power is too wide and hence it is important for the court to do it wisely and according to the guidelines laid down by the high courts and supreme courts from time to time. Section 482 in its current form has seen several changes with the changing times and needs of the hour, and by the guidelines framed by the Supreme Court in several of its judgments. The courts are constrained to do so as the said section, which gives wide power to the High Court, are highly abused by the law practitioner. Section 482 of the CRPC has made its space in CRPC in order to enable the High Courts to provide proper justice and at the same time to curb filing of fictitious complaints just to avenge personal grudges. So, this was all about Section 482 of the CRPC, and it is giving justice to lot of the citizens of this country. So in the end, I will say thanks you all for watching. God bless you all.